Afternoon, everyone. My name is Ryan Susky. I am the Director of Programs and the Coordinator for the Moot Court program at the Ohio Center for Law-Related Education. And you're joining us for the championship round of the 2024 Ohio Moot Court competition. Before we begin today, I'd like to go ahead and thank the sponsors who make this competition possible. OCLRE is grateful to have the sponsorship of the Supreme Court of Ohio, the Office of the Ohio Attorney General, the Ohio State Bar Association, the ACLU of Ohio Foundation, and we receive significant grant support from the Ohio State Bar Foundation. In a moment, I'm going to have the judges introduce themselves, and then the students will introduce themselves when they come to the podium to begin their arguments. Arguments in this championship round are going to last for 1 hour, excluding the introductions and feedback. These two teams have fought hard in 4 preliminary rounds, followed by a semifinal, to earn their place here today in the final round of this competition. Congratulations to both teams, and I wish you best of luck. At this time, I'm going to hand things over to our judges to give their introductions and begin our final round.
Good afternoon. I was a bit louder than I expected. Good afternoon. My name is Benjamin Tracy. I'm a senior judicial attorney here at the Supreme Court of Ohio, and today I will be playing the role of your Chief Justice. Turn it over to my associates.
Hi, I'm Mike Hendershot. I'm the Chief Deputy Solicitor General for the Attorney General of Ohio.
My name is Attorney Hannah Bott-Kendody, and I practice in my own private field serving the LGBT community of Columbus, Ohio.
I'm Ron Wadlinger. I'm a senior judicial attorney with Justice Pat Fisher here at the Ohio Supreme Court.
Hello, I'm Tiffany Carwile. I'm an attorney here in Columbus with the law firm of Arnold and Clifford.
With that out of the way, we'll now open the court. The court will now hear arguments in the case Julie Jenkins v. State of Buckeye. Petitioner, when ready, you may begin your arguments. Please begin by introducing yourself and giving us your student code.
Good afternoon, Your Honors. My name is Alexander Ament. My student code is C2. I will be arguing the constitutional issue for the petitioner. At this time, I would like to reserve 4 minutes for rebuttal. Your Honors, Chief Justice, opposing counsel, may it please the court, this is a case about a girl who spoke out against a political candidate and was capriciously silenced for it, unconstitutionally so. Now, as I am arguing the constitutional issue today, that is, Jenkins's First Amendment rights were infringed upon when she was convicted of violating Buckeye Code section 3517.21A1. As Animal Legal Defense Fund v. Herbert notes, constitutional challenges, specifically the First Amendment, proceed in 3 phases. Number 1, we have to determine whether the statute actually implicates free speech and First Amendment rights. If it does, we go to step 2, determining whether the statute is content neutral or not. If the statute is content neutral, we must apply intermediate scrutiny. If it is not, we must apply strict scrutiny. And then on step 3, we apply the appropriate scrutiny and determine whether the statute passes or not. So I will begin with the first issue, and that is Buckeye Code 3517.21A1 does implicate Jenkins's First Amendment rights. There are several ways to approach it, and I'll start with this one. If we look at the lower court's ruling, they found that the statute does implicate First Amendment rights. In fact, on page 36, referencing the statute, I quote, the court said, "This does have some impact on reporting on political campaigns. So this court will examine the statute as it is written under the First Amendment." And thus, the statute goes on to the rest of the test. But even if we're not extrapolating from the lower court's ruling, we can approach this from another angle. Buckeye Code 3517.21 doesn't explicitly mention speech. So it might be considered a generally applicable law that incidentally infringes upon speech, because it certainly infringed somehow. The question we must determine then, the line we must draw, is whether, according to Cohen v. Cowles Media Company and Capital Cities, Food Lion v. Capital Cities / ABC, is whether the law is generally applicable or specifically targets speech in its effect. It is the position of the petitioner that this law is not generally applicable. Food Lion says that a law is not generally applicable where it begins to target specific speech or specific groups, like the press. And if we look at what the Buckeye Code 3517 targets, it specifically targets political campaigns. Now, at the heart of politics is speech. It is the communication of ideas and the persuasion of others. So simply by the fact that this regulates political campaigns, it's regulating speech.
Well, hold on, counsel. Does it regulate campaigns, or does it regulate people who would illicitly try to insert themselves into a campaign for essentially bad action?
Well, you could say, Your Honor, that it does try to regulate illicit individuals, the statute, but it's doing that in an area that is particularly speech heavy. If we look at Jenkins serving, I mean, what is she doing when she's serving? She's going out, making calls, talking to people. She's doing all of these speech-related activities.
Was that your test, counsel, for statute, whether it just regulates something that's speech heavy? I mean, what if I just think about the antitrust statutes, and most conspiracies are speech, right? Is the antitrust statute, is it a speech regulation?
Well, Your Honor, unfortunately, as we do not have any antitrust statutes in this packet, I'm not sure exactly what you're referring to, but I will comment on the...
Well, I don't care about the text of the antitrust statute,
Okay.
just the idea. It makes conspiracies to restrain trade illegal, but the conspiracy might just be based on speech. In fact, that's common.
Well, conspiracies are a particular area, a particularly unregulated area, so First Amendment rights don't apply there. In fact, this is actually mentioned when we get to the third point. Conspiracies can be, at least the speech in conspiracies, can be regulated because that's speech integral to criminal action, whereas Jenkins's speech is not integral to criminal action. So when it comes to conspiracies...
This is a criminal statute, isn't it?
You're right, Your Honor, but the speech itself is not integral to the crime. Jenkins can violate this statute without having particularly, or there are certain situations in which someone could violate this statute without particularly having engaged in speech. Usually when you're...
What about fraud? I mean, fraud is speech that is prohibited by statute and it's criminal.
Yes.
But that can be regulated. So it can't be just, if it's speech, then it gets protected. So where are you drawing your line?
You're right, Your Honor. That's a good question. Are you referring in this case to the misleading statements that Jenkins made, or to her publications, or just in general?
Neither. It seemed like you were making a broad statement that if speech is involved with a regulation, then the First Amendment's going to always apply. And when we were talking, you were trying to say conspiracy is different because the speech isn't integral to the crime. For fraud, the speech is integral to the crime. That is the crime, the speech. So where do you draw the line? Fraud doesn't implicate the First Amendment, but this does. But so where's your line?
That's a good question, Your Honor. The line is, and if we look at the same case before that I was mentioning for historically unprotected speech, U.S. v. Alvarez, we can see fraud is another one of those pieces of speech that falls under historically unprotected. The difference between fraud and what Jenkins is doing is that fraud, number one, it has to be obviously false, it has to be misleading statements. And number two, there has to be a legally cognizable harm that goes along with it. That's really what allows the government to regulate it. With Jenkins's speech, there has been no legally cognizable harm on the record.
Isn't the statute have the harm already in there that with the intent to impede the election?
Well, Your Honor, the statute requires that someone has the intent to impede, But the statute doesn't require that that effect actually comes about. So it might be that someone releases information with the intent to harm the campaign, but ultimately it falls flat and that doesn't actually happen. So no, the statute doesn't require a legally cognizable harm in it. So it's not necessarily regulating fraud.
You could have attempted fraud where it doesn't actually occur, but it's still a crime.
You're referring to someone who attempts to perpetrate fraud and it just like an inchoate crime?
If you attempt to perpetrate fraud, but the person doesn't buy it, you can still be criminally tried for attempted fraud. So in this case, maybe her intent didn't wasn't able to realize the intent, but it still could be a crime.
Well, at that point, Your Honor, I think we're getting into the intent issue here, and that's probably best left to the statutory part. In that case, I'd say you are correct. If Jenkins has an intent to perpetrate fraud, then her speech might not be regulated. But there's nothing on the record that suggests Jenkins is trying to be fraudulent here. Now, getting into the issue of content neutrality, this is pretty clear-cut. If we look at the case Reed v. Town of Gilbert, Arizona.
Sorry, counsel, I don't want to belabor the point, but I did want to ask you one final thing about why the First Amendment is applicable here at all. It sounds like what I hear you saying is that someone can violate this statute, and as I look at the statute, it appears that someone can violate it without speaking at all, right? I mean, all you have to do is join a political campaign with intent to affect the outcome or impede it. You could keep that intent to yourself. You could never say anything to anybody. You could be entirely silent the whole time. So why is this facially a First Amendment issue? Or is it facially a First Amendment issue? Is your challenge as applied?
Well, Your Honor, like I was saying before, well, perhaps a plain text reading doesn't reveal that the statute explicitly criminalizes speech. We do see in one particular part it happens to suppress speech, and that says if you try to serve with the purpose of reporting information to your employer. So we can see there that it's specifically criminalizing speech that you're reporting to your employer. Additionally, in general, this is regulating political campaigns, and the whole purpose of a political campaign is to get the word out about political candidates.
Maybe to follow up on the Chief Justice's question, of the cases that you have briefed, what is the closest analog to this statute that shows it might implicate the First Amendment?
That is a good question, Your Honor. We have several cases, depending on which part you're referring to. If you're talking about potentially fraudulent statements that...
No, I'm just talking about in general, trying to build off the Chief's question. What is most closely analogous to this? A case that has looked at a similar statute and concluded, yes, this implicates the First Amendment.
That would likely be Food Line Incorporated versus Capital Cities ABC Incorporated. What happened there is several individuals...
Was that about a statute? I guess maybe you can refresh me on that.
I do not have the statute before me, but it was, whatever the violation in question was. But what happened in Food Line is several individuals infiltrated, similar to how we might say Jenkins did, this company Food Line, and they reported on it, and then they later published this information, and ultimately it was found that they could not be held liable for reporting that information. Just as Jenkins here could not be criminalized for what she's doing because it falls within the purview of the First Amendment. It appears I am almost out of time, Your Honors, so thank you.
Petitioner, when you're ready.
Your Honors, my name is Max Vipora. My code is C1, and I am representing the petitioner, Julie Jenkins, in this case, and in the statutory effect. Your Honors, opposing counsel, may it please the court. Julie Jenkins should not be convicted of violating Buckeye Code 3517.21A1. As to violate a statute, a person needs to be an agent or employee of the campaign and intend to affect the outcome of the election. In this case, Julie Jenkins was neither an employee nor an agent of Richard's campaign, nor did she volunteer with the campaign with the intent to affect the outcome. Your Honors, Julie is no criminal. She is a teenager with the dream of becoming a journalist who was punished for publishing the truth. So the first question we have to ask.
Well, no, Counselor, she wasn't punished for publishing the truth. She was punished for infiltrating a campaign to solicit secret information that wouldn't have been available to her otherwise for the benefit of her employer, who required her to disclose at least one article a week. So she didn't do what you said. In fact, she did something knowingly and with intent. How can you say otherwise?
I disagree. I believe she did not have the intent to do so. As in,
Sorry, to do what? There are several elements here. What is it you're saying she lacked the intent to do?
she lacked the intent to affect or impede the election. As in Virginia v. Black, it states that the court argued that you cannot equate action with intent. As when she posted this information about what happened in the case, it said that Virginia v. Black argued that you cannot equate action with intent. The action of posting on social media might cause harm on Richard's campaign, but it is not prima facie evidence that Jenkins intended to harm Richard's campaign.
Well, let me ask you this, Counselor. Can you defend her intent of joining the campaign in the first place to follow what could be called a hunch? Would she have joined the campaign otherwise if she didn't believe that the 10% tax was not in fact fully truthful? Would she have done so of her own volition if she hadn't had that information?
Can you repeat that?
Sure. So you're here to demonstrate whether or not she had an intent. You speak to the action that happened at the end of this fact. However, at the outset, she would not have joined the campaign if she did not think that there was some sort of fraudulent disinformation going on. Isn't that right? She had no intention to do so before she heard the 10% tax and thought that there was a nagging question in her head as to whether that was actually truthful. So she joined the campaign with the intent of discovering whether or not it was. She went to that conference room to clean it to get closer to the campaign staff. That was intent.
Well, first off, the part about her being in the conference room, she was given that order prior to by one of the agents of Richard's, and he happened to come into the conference room, and they actually acknowledged each other at that point, and he still went on to talk about the information. So at that point, she was not infiltrating on a hush-hush. She was explicitly there, and he knew it. And on the second part about having an intent to do so, at the beginning of the process of the campaign, she was unsure of who she wanted to vote for. She was intrigued by both cases, and particularly she was intrigued by Richard's campaign due to the sustainability tax having an effect on, I believe it was her grandfather's coal mine and her own personal seeings towards environmental efforts.
Counsel, would you agree that she joined the campaign in order to obtain information for a news article?
I disagree, Your Honor.
What was her intent of joining the campaign then?
Originally, her intent when joining the campaign was to uncover the truth, not necessarily to reveal it, but just for her own personal benefit of being able to know if her suspicions, if her view on both sides of campaigns, if it could be correct.
How can you, go ahead.
In here, that seems like a factual dispute to me, what you just described. And we have a conviction from a fact finder, right? So help me out with that. I mean, what you're saying is maybe a plausible way to read what happened, but where we sit here, it's after we have a fact finding that I think cuts against what you're saying.
Can you elaborate further? I apologize.
Yeah, well, maybe it's an unfair question. So here we have a conviction that comes from fact-finding, right, in, I think, the municipal court here. And I feel like it seems like you're fighting the facts of what happened. We have a fact-finding already. Don't we have to take that as a given from the conviction itself?
I apologize. I'm trying to understand your question.
Well, or maybe you could point me to what the version you were offering my colleague about sort of what was her intent at the start of all this. What would you point me to support that? Like, where would I look in the record? What would
In the
would show?
facts of the case on page, I apologize, the facts of the case, the third paragraph, it states that third or fourth paragraph, it states that she had a hunch, some nagging feeling about Richards. And it was that she was not being completely honest. She had the nagging feeling, but she wasn't completely sure of which way or the other. She was impartial to whether he was trying to tell the truth about the campaign or wasn't trying to hurt in his own campaign.
Counsel, she went to a debate and the purpose of that was to write an article on the debate, right?
Yes, Your Honor.
Okay. And she had a hunch that Mr. Richards was lying, correct?
Yes, Your Honor.
And so she joins the campaign, correct?
Yes, Your Honor.
She then once she gets information that supports her hunch, her first move is to go home and tweet about it, correct?
I do not believe so. I believe her first move actually was to finish setting up the conference room.
Okay.
Finish her task of that she was given by the.
Fair. When she leaves the work, her first thing when she gets home is to tweet about it, correct?
I believe she wanted to prepare for some kind of writing that she was going to do that Friday, but then she wrote down the tweet about him lying towards the about him lying on the sustainability tax on Twitter to the public.
Okay. So she tweets about it, maybe debate of how quickly she does it, but that's one of her first actions is the tweet about it. How can you say, based on that series of events, that she did not have an intent to write an article relating to Richards on what she discovered in his campaign, good or bad of whatever she discovered?
That's a great question. I believe that this intent that you're speaking of occurred after joining the campaign, after learning more about her volunteer work, and after hearing this. But again, her original intent from the very beginning was just to join the campaign, engage in the volunteer work that she was handed, and then thus go. And then she heard the news, with which Richards could have easily gone into a different room, or there are other precautions he could have taken to not say it, but he ended up deliberately was in the room talking about it with his man.
Well, isn't this the very injury the statute is there to protect, the cooling of political association, including the fact that you can't have conversations in front of your very own volunteers for fear of being reported to the press? So my question is why does the onus fall on the candidate and not the volunteer? Isn't the privacy of the candidate something that should be presumed with someone that is actively volunteering with their campaign?
Well, this is where we can come to the agency and employee relationship, with which it states that her involvement in this case was just as a volunteer. She was neither an agent nor an employee. So this case that we're talking about, on her reporting what she heard about, she has no, well, as the case of Shalash v. Liquor Control Company, or Control Commission defines an agent as someone who has the power to bind the principal. She has no power. I don't know if this is the correct way of saying it, but she has no personal need to have to keep this to herself. There's nothing, as being just a volunteer, she has nothing holding her back from being able to say what she has to say, simply because she heard it in public in a place that he knew he was on the phone in the conference room. She knew he was there. They acknowledged each other. And he was able to speak So from that presumption, you can say that she was able to speak it because obviously he was okay with her being in the room when she said so.
Was he really in public, or weren't they at their campaign location, the headquarters, or?
Paul, it was a conference room, yes, not public.
Okay, thank you.
Let me ask you this. The fifth element of the statute says that it has to be for the purpose of acting to impede the conduct or of reporting information to the employee's employer or the agent's principal without the knowledge of the candidate. Is posting something on Twitter and simply using a handle for an outside organization equatable to reporting to your employer in the same way it might be, say, if she wrote an article and submitted it for pay?
I think this comes back to her original intent in the first place. And when you take that second half of the article, it still says you have to have knowing and with intent to affect the outcome of such a campaign. Her intent of the entire campaign was to uncover the truth. Whether her reporting did hinder, helped, or had no impact on his campaign was not the point. It was just to uncover the truth about
Yeah, that's not my question. I'm not asking whether or not her actions or her speech impeded the conduct of the campaign. I'm asking if it counts as reporting to your employer, a part of this statute, if you're simply using your own personal Twitter handle to repeat the information.
And I apologize if I'm confusing you, but this only follows in line if she has shown knowingly and with intent wanted to affect the outcome of such a campaign, with which I disagree that she did not have an intent to affect the outcome of the campaign.
So
would
my
say we
question
just-
isn't relevant because your intent hasn't been justified.
Exactly.
Thank you so much for that.
Go ahead.
All right. And talking about the A1, the first part of A1, it states that someone has to serve or place another person to serve as an agent or employee in the election campaign. Well, I'm not sure if this point that it applies and if it's going to convince you, but I don't believe she was either of the sort. In Shalash v. Or GRLP Inners Incorporated versus Sethi, it defines an agent as someone whose actions are attributed to the principal rather than himself because the agent is standing in the shoes of the principal. Another definition in Shalash v. Liquor Control Commission, once again, states that an agent has one who has the power to bind the principal by his actions. In this case law, she has no bind to Richards. Richards has no bind to her, as anything she says will not affect whether he actually does it. If she was to, let's say, post this Twitter post, he easily can go back and say, I repute this and I disagree with this, which
What is your best authority for, I guess, lack of agency here? I don't remember the specifics of those two cases you cited. I'm familiar with the general test for agency and so forth, but what's your best authority for lack of agency or employment here?
the power to bind somebody to a principle.
Well, I don't just mean the test. Like, what is your best case authority? We only have the one statute here. Like, of the cases that discuss agency or employment, that seems to be less likely here. But what is your best authority to convince me there's not an agent-principal relationship here?
In, I believe, Alex stated Food Line versus ABC, it states that the journalists are working on behalf of ABC. They joined Food Line as employees. Both times they're under direct contract, and now that I'm going to go into employee because I have a better explanation, is that it says a person who works in the service of another person, the employer, under an expressed or implied contract of hire in which the employer has a right to control the details of work performance. In this case, they were under contract of hire not once but twice under both ABC and under Food Line, and in this case it's completely different where she was neither under contract of hire under both companies.
Counsel, would this change our mind if she was a paid volunteer, or if she received some sort of benefit? Would that change your assessment?
It would, but that does not have any effect on this case, as that them specifically stating that she was a volunteer would bring out the point that she is not receiving in compensation any pay, and thus is not liable to the same charges as somebody who is a contracted employee.
The benefit that you have to receive only money in order to be an employee, or can there be
No,
other
I do not
benefits?
believe so. I believe that's all the time I have. But if you want me to continue, I will continue.
You may finish answering the question and briefly conclude.
Sorry, can you restate that?
All I was wondering, is pay the only thing that would qualify them as an employee, or can another benefit?
No, I believe other benefits can count, but in this case, she is not receiving any benefit. She is donating her time. It would be a transactional relationship, and thus this does not apply to her as an employee. And in that case, Julie Jenkins, Your Honors, should not be liable to Buckeye Code 3517.21, as she was just trying to uncover the truth with the intent to, again, uncover the truth. Thank you.
Thank you. Respondents, whenever you're ready.
Good afternoon, Your Honors. My name is Thomas Slew, and my code is E4. I will be arguing the First Amendment issue for the respondent. Mr. Chief Justice, and may it please the court. The First Amendment balances freedom. The freedom to act, to express ourselves, and to speak. Yet the main focus of this case, Julie Jenkins, was always free to begin with. And this is because Buckeye Code 3517.21 doesn't violate the First Amendment of the United States Constitution. Now, this conclusion follows for three reasons. Number one, the prohibition on campaign infiltration, Buckeye Code 3517.21, is a content-neutral restriction. And number two, because the statute is a content-neutral restriction, the correct standard set is intermediate scrutiny. And number three, 3517.21 has several limitations, and thus it satisfies the narrow tailoring of the intermediate scrutiny test. Now, I believe Petitioner mentioned that Buckeye Code specifically targets political speech, but we as the respondent have to disagree, seeing that it doesn't regulate speech, but rather fraudulent behavior to obtain that information. Instead, it deals with matters entirely of fraud. And for that reason, we agree with the lower court's decision that 3517.21 has no implications of the First Amendment. Zemel versus Rusk set this standard in 1965, where it ruled that the means of obtaining information does not hold the same unrestrained rights to gather information as it does speech. And while Buckeye's intent with 3517.21 was mainly with fraud, we still have to acknowledge the First Amendment challenge raised by Jenkins. Now, in Jenkins' scenario, she volunteered with Richards' campaign after a feeling that he was not telling the truth, but this feeling was only obtained after she appeared on Richards' debate at the gubernatorial primary and realized that his sustainability tax would take a much larger upfront cost. That's when she then decided to volunteer with the campaign in order to investigate further. And in order to gain employment with that campaign, she not only expressed her support for Richards, but mentioned that she would do what she could to get him elected. Now, it's also important that we look in the lower courts, where Jenkins made it clear in her trial and her testimony that she wasn't sure where her vote was going to go. Her expressing her support for Richards and saying she would do what she could in order to get him elected was a false pretense. It was a misrepresentation of what she actually thought. Now we turn to U.S. versus Alvarez in 2012. Cases such as fraud or false claims to secure valuable considerations, and in this case, employment, the government generally establishes that they may restrict speech without a violation of the First Amendment.
But Counselor, does Alvarez even apply here, since Ms. Jenkins was not employed by the campaign but merely donated her time?
Well, Your Honors, we would argue that she was employed as a volunteer under Richards' campaign, seeing that Richards and his campaign was able to exert control, and there was an implied contract.
Well, I understand the implication, his ability to control her. However, doesn't the employment contract also create a implication that she could then bind him as his agent? That didn't exist in this case, did it?
Well, we would disagree with that, Your Honor, seeing that Jenkins did have the power to bind Richards because she was a representative. Seeing that she was a volunteer of the volunteer, she was a representative of Richards' campaign, and what actions she did would reflect on Richards' campaign as a whole.
But she didn't speak for him. She spoke in support of him as her own individual, but she didn't speak on his behalf in the same way that, say, a press secretary would or a campaign manager who literally speaks for the candidate.
That's correct. She wasn't a campaign manager or a press secretary, but she was assigned what to say by Richards. She was speaking for him in that case to other potential voters with her phone calls from 5 p.m. to 7.
Would you say that all volunteers have the power to bind? If I volunteer for the Red Cross, I volunteer here. Are volunteers always agents of the entity they're volunteering for?
No, Your Honor. But
So what makes her an agent but allows you to say no to my categorical question?
well, I believe this is more of a statutory issue. The ability that gives Jenkins the ability to bind Richards would once again be the fact that she was making calls from 5 p.m. to 7 p.m. as essentially a speaking head for Richards. Volunteering programs may vary, but in this case of Jenkins, she was speaking for Richards. Richards assigned her what to say, and she supported that request.
Counsel, you said that you were analogizing this to things from Alvarez that didn't implicate the First Amendment, fraud in particular. But isn't it true that you can violate this statute without committing fraud, without lying to your potential employer?
I'm sorry, could you rephrase?
Well, in this case, she did say, well, she gave reasons for why she wanted to join, and they seem false. But it's just as possible that you don't have those type of questions, and it's just, what experience do you have, and things like that, and in questions that that the person answers truthfully. She could still have the intent to violate the statute. So it's not necessarily. Would you agree that the statute's not limited to fraud?
Yes, Your Honor, we would agree with that. We reference U.S. versus Alvarez because although 3517.21 doesn't require an individual to gain employment through false pretenses or fraud, that is what Jenkins did in this case by expressing her support.
Well, the statute reaches more than fraud. Doesn't that create the constitutional problem that Alvarez flagged?
Well, while that's correct, Your Honor, it's still important to acknowledge that Jenkins did use a misrepresentation of herself in order to gain employment as a volunteer under Richards' campaign. That's why we turn to U.S. versus Alvarez. We understand that it's not entirely an analogous case, but because it sets the standard that in cases such as fraud or false claims, the government may restrict speech without a violation of the First Amendment.
So do you concede then that even if this statute doesn't violate the First Amendment facially, and even if it doesn't violate it as applied in this case, that there may be cases in which it would violate the First Amendment?
No, Your Honor.
You think in no case does it ever violate the First Amendment?
No, Your Honor. And this is because we don't believe that 3517.21 is implicated with the First Amendment. We believe it's designed to prevent campaign infiltration in terms of fraud. In order to gain candidates the security that their employees and their volunteers will be loyal to them and wouldn't have to worry about investigators such as moles.
How then do you respond to the self-evident fact that the United States has a long and storied history of investigative reporting, which is generally thought to be protected by the First Amendment?
Well, 3517.21 isn't violated from Jenkins because she was an investigative journalist. It's entirely because of her false pretense here, her intent to impede or affect the outcome of the campaign. Had she simply written a paper on her ideas of the sustainability tax, talked about how, in her experience and her thoughts on the sustainability tax, that it would take a much larger upfront cost, there would be no violation here.
Okay, what if she didn't go in under false pretenses? What if she just showed up at the campaign office and they were really hurting for volunteers, and she walked in and she said, "I'd like to volunteer," and she didn't say anything else, and she showed up, she did her bit as a volunteer, incidentally she came by information which she then published?
Well, we
Still
would
a problem?
Yes, Your Honor, and this is
Why?
because, well, this is because we would then turn to her original intent to
What if she had no intent going in, right? What if she showed up because they're desperate, and then all she reports is, this campaign is really desperate?
Well, if she had no intent to impede or affect the outcome of the campaign.
Or she does then, though, right? She then makes that statement. They were so desperate they took me without asking me any questions, with the intent of affecting the election.
I'm sorry, Your Honor, could you rephrase?
Yeah, I guess the hypothetical is, just again building off the Chief Justice, she shows up at the campaign headquarters, they're desperate for volunteers, so they take her in without asking any questions. And then what she does is she writes a story, she reports, this campaign is so hard up for resources that they'll take anybody off the street. And she makes that statement with the intent of affecting the election.
Well, we believe that if she had gone into the campaign without the intent to impede or affect the outcome of the campaign, that would be fine. It would be within her right as freedom of the press to do so. However,
Fine because of the First Amendment, or fine for some other reason?
I'm sorry?
Why would she not be liable in that hypothetical?
Well, the statute emphasizes that no person during the course of any campaign shall knowingly and with intent to affect the outcome of the campaign do the following in terms of reporting information to the agent without their knowledge. And in the case of Jenkins as well, she didn't satisfy that requirement by telling Richards that she would be an investigative journalist.
So counsel, does it matter? So counsel, does it matter when the intent is acquired? Does it have to be before joining the campaign?
It must be during the course of any campaign for nomination or election to public office. Anything besides that, no, Your Honor.
Okay.
So it sounds like what you're saying is that the only way to not violate the statute is to not violate the statute. And I'm sorry that seems like a tautology, but is there a way to violate the statute and yet be protected by the First Amendment? In other words, could you violate the terms of this statute but be not guilty because the First Amendment protects you? Does the First Amendment have anything to say about this statute?
We agree with that, Your Honor. We don't believe that the First Amendment has any implications on 3517.21, primarily because of the intent of Buckeye establishing this statute to prevent campaign infiltration.
Counsel, say we disagree that the First Amendment has nothing to say with this. Can you go into what level of scrutiny and why you meet that level?
Yes, Your Honor. We would turn to intermediate scrutiny, simply because this statute is not content-based. Nowhere does this code reference false statements, nor a misrepresentation of any information or speech in general. The elements
Isn't it content-based in this sense? To figure out if the statute applies, you have to know if the person's either thoughts or speech are to affect the election, right? That seems to be squarely what Reed versus Town of Gilbert said was the test for content-based speech.
Sorry, could you repeat that question?
Sure. To figure out if somebody violated the statute, it seems like you have to probe their mind or their speech to figure out whether they had the intent to affect the election. And that seems like that is a content-based, just like the sign statute in Reed, that is a content-based examination.
Well, generally, the government is allowed to regulate expressive activity as it is justified without any reference to the context in the speech being regulated. Now, once again, the campaign isn't enforcing 3517.21 on Jenkins because of the material that she produced, but rather because of her.
But it is enforcing it, isn't it, because she wanted to affect the campaign? If she wanted to help the campaign, would this statute apply to her?
Yes, Your Honor. The statute doesn't reference positive or negative statements.
But isn't it true that our Constitution, the First Amendment applied to the states through the 14th, does generally allow content-based messaging to have First Amendment protection unless it would incite lawless action, obscenity, defamation, criminal conduct, fighting words. None of that was the case here. So why doesn't the First Amendment apply to this content, this speech?
I'm sorry, could you rephrase?
You said that the First Amendment doesn't apply here, even if it's content-based, because Jenkins acted fraudulently, right?
Yes, Your Honor.
So Alvarez, the case you're relying upon, says, as a general matter, the First Amendment means the government has no power to restrict expression in messages or ideas except in these limited circumstances that would cause imminent harm. So how did the speech in Jenkins fall outside of the circumstances where the First Amendment would apply?
Well, I'd like to circle back, and I apologize, but my argument on the statute not being of reference to the First Amendment is under the implication that this statute is content neutral, purely off the grounds that, once again, the statute doesn't regulate speech, nor does it focus on any specific type of speech.
Doesn't it focus on political speech because it's only applicable in a political campaign?
Well, that's correct, Your Honor. This would be used to serve the government interest of keeping campaigns, of keeping the integrity of campaigns. And thus, we believe that 3517.21 should be looked under intermediate scrutiny. And with the limitations of the elements under the statute, especially the knowing and with intent to affect the outcome, these elements narrow the statute to serve a compelling interest, and the narrow tailor of intermediate scrutiny is therefore satisfied. Now, I see that my time is about to run out, so thank you for your time, Your Honors, and we respectfully request that this court affirms.
Thank you, counsel. Respondent, co-counsel, when you're ready.
Good afternoon, Your Honors. My name is Lucy Taylor. My code is E3, and I will be arguing for the statutory issue for the respondent. Mr. Chief Justice, and may it please the court. Integrity is used to guide us through all aspects of life. Buckeye Code 3517.21 is intended to protect the integrity of political campaigns and elections. Julie Jenkins challenges, under the First Amendment, the constitutionality of Buckeye Code 3517.21, which she was convicted of violating when she made a post on Twitter during and regarding Ryan Richards' campaign.
Counsel, I don't want to nitpick or jump down your throat, but intended to protect the integrity of elections, how does putting campaigns out of reach of investigative journalists help achieve election integrity?
Could you rephrase the question?
Yes. How does a statute that prevents reporters from gaining access to campaigns make elections more truthful?
Your Honor, we see that the statute doesn't completely prevent journalists from gaining information. The statute lays foundation to prevent or to we see that the statute prevents the means that the information is gained by journalists or investigators.
Could you lay out for me then, just hypothetically, doesn't do out this case, what it would look like for a journalist to not run afoul of this statute and to do meaningful reporting on a statute, on a campaign?
The soul of the statute is the intent behind the intent of, in this case, why Julie Jenkins joined Ryan Richards' campaign. She intended to impede on the campaign's outcome because she, as a reporter, she would know that any information she collected about the campaign could affect the public view, therefore affecting the election. And since Julie Jenkins has such vast knowledge of the issues at hand, specifically the sustainability tax, she understands the importance of this proposal by the Nature Party. She would know that any information that she gives could change the outlook of the public, therefore changing voters' minds. And
so I understand, counsel, that the state's position is that Julie Jenkins violated this statute because she had some intent vis-a-vis this candidate, but to to go off my colleague's question here, what if that were not the case? What if a reporter, let's say from a foreign news organization, such as the BBC, for example, who has no interest at all in American politics and just is here to report, decides that a good way to get a story is to join a campaign, duly gets the story, is totally agnostic as to what the story is, and then reports it without a care at all about whether or not it changes the result of the election? Problem or not?
Are you referring to if there was no intention at all behind the actions of the reporter?
I'm basically asking, could someone do exactly what Jenkins did, but without the arguable subjective intent of caring about how this election turns out, and be okay under this statute?
There's a number of elements under the statute that need to be met in order for it to be violated. So the sole issue is intent. So supposedly without intent, there would be no violation of the code. However, in this case, Julie Jenkins showed clear intent to impede on the outcome.
So we need to care then what the defendant thinks about the candidate in order to know whether they violated the statute. They need then to have a view about basically how their conduct is going to change the result. Is that your position?
Yes, Your Honor.
Thank you, counsel.
Could you talk about the agent and employee element and just point me to the best support in the record here as to how the state has satisfied its burden of proof there?
Yes, the issue of whether or not Jenkins was an agent or employee of Richard's campaign can be determined by the holding of Shalash versus Liquor Control Commission. This holding sets forth the standard for defining an agency relationship as a consensual fiduciary relationship.
Let me stop you there. What is the fiduciary status of Jenkins here as a volunteer? I mean, is every volunteer a fiduciary? And if not, how is she a fiduciary?
We see that Jenkins is able to bind the principal, being Ryan Reynolds, to her own actions. Julie Jenkins was given a set schedule of what she should when she should have been making phone calls.
It sounds more like she was bound to do these things. Like, if you want to keep volunteering for us, work these hours, do this, do this, do this. But how does she bind the campaign? That's what matters for agency, right?
Yes, Your
I'm
Honor.
looking at it from the side of the person who's supposedly the agent.
During the phone calls that Julie Jenkins would have conducted for potential voters or any citizens, she would step into the shoes of Ryan Reynolds. Whether or not the statements that she made were legally binding, the public would hear any statements that she made and assume that that was the intention behind Ryan Reynolds' campaign. So anything that Jenkins could have said over the phone, voters see that as Ryan Reynolds
I mostly think of agency as requiring legally binding in some sense, whether it's to a contract or something else. So can you direct me to where's the law that says you can be an agent short of legally binding the principal?
Could you repeat the question?
Yeah, I'm just wondering, I guess, I could be wrong about this. And that's what I guess you're here to show me. I think of agency as having some legally binding force on the principal. And it seems like you're saying she didn't have that power. Where do I look to see that is what is meant by agent? Or maybe the statute uses a different meaning of agent than the common law meaning or the meaning from the case there. I just want to understand where we understand that she is an agent despite lack of legally binding the principal.
Your Honor, we see that Jenkins does legally bind the principal in this case. For example, the day that she was setting up the conference room when she overheard the telephone conversation, when she was setting up the conference room, if she had hired a catering company to bring food. As a volunteer, any money that was to be spent would be through Richard's campaign. Therefore, Richards would be bound to pay for that.
Counsel, where in the record is it that that any contract she entered into, it would be binding on Richards? Is there any record evidence that she would have had the authority to hire a caterer on behalf of Richards' campaign and make Richards pay for it?
As a volunteer, she was serving directly under Richard's campaign. Therefore, any actions that she does are a reflection of Richard's campaign.
So, counsel, are you having us equate her agency due to the fact that she wouldn't be saying these words, she wouldn't be making this phone call, she wouldn't be following this script or giving her time if she wasn't acting on behalf of Ryan Richards?
Yes.
And that when she is speaking to these individuals, that the statements she's making are being therefore attributed to Ryan Richards?
Yes.
Okay.
Say I disagree with you on agency, and I don't think there's an agency relationship. Your friends on the other side mentioned that it wasn't the only benefit, or that money isn't the only benefit that could be received to create an employment relationship. What benefit did Ms. Jenkins receive in her volunteer relationship with the campaign?
There's where we can look at the holding of Animal Legal Defense Fund, which holds that false statements are protected by the First Amendment only if they do not cause legally cognizable harm or provide material gain to the speaker.
I think so for my understanding, that is an employment relationship. You have a express contract or an implied contract. A contract requires benefits for both parties. So she was giving the campaign a benefit by donating her time. What benefit did she receive from the campaign in order to create that implied employment contract?
This goes back to the intention of Julie Jenkins. She knew that she would be able to report on Ryan Richards' campaign regardless of what information that she was going to receive. Well,
a contract has to be agreeable, mutual. So my understanding is the campaign wasn't agreeing to give her information to publish. Otherwise, if they were, then you're not violating the statute anyways. So what did the campaign voluntarily give her in order for her to voluntarily give her time?
In a sense, the campaign provided her with a journalist opportunity. She intended to volunteer with the campaign for the intention of creating a story based off of her.
Yeah, we understand that in the past tense looking back. That was her intention. That was her consideration, was access, right? Information. But what I think my co-justice is asking is, did the campaign know they were giving that consideration? Or did they think that as a volunteer, she's working out of the goodness of her heart because she's a politically active individual? They're not thinking, because you volunteer, you will get this, right? There's no intention on their part of providing her with a benefit. That's the difference. We know that she got a benefit. It's in the Twitter handle. But in this instance, can there be an employment relationship if there was no intentional or knowing benefit being provided by the principal?
Your Honor, we see that the campaign was working for a collective result. Julie Jenkins told the Ryan Richards campaign that she was in full support and that she would do whatever she could to help him get elected. Deep down, she knew that she had a nagging feeling and was suspicious of what Ryan Richards was presenting with the sustainability tax, which leads to the Julie Jenkins was working to help Ryan Richards get elected, essentially. The campaign provided the opportunity for this outcome.
Do you think volunteers sometimes volunteer for campaigns in order to pad their resumes?
In what sense?
Do you think it is of benefit to a volunteer to have worked on a campaign? Full stop.
I'm sorry, I'm not understanding.
Does the experience you get from being on a campaign, can that be considered a benefit?
Yes, especially in Julie Jenkins' standpoint, where she's very passionate about the standings of the Nature Party. She knows that there are pros and cons to the sustainability tax that Ryan Richards is promoting, and therefore she gains experience as a journalist and learns more about the campaign.
I have one question I'm not sure we've talked about with the statute. So the A part of the statute says affect the outcome of a campaign. And then in little one, it says acting to impede the conduct of the campaign. Those are different phrases. Are those different elements because they have different words in them that you've had to satisfy to sustain this conviction?
The outcome of the campaign is, of course, I see that my time is running out. Shall I?
You may finish answering the question and briefly conclude.
Could you repeat the question, please?
Sure. I'm just wondering if the difference between the wording of affect the outcome of the campaign and impede the conduct of the campaign, those are different phrases. So normally I think that means they have different meaning. Do you view those as separate elements? Do you have to satisfy both of those to sustain the conviction here?
We see that those elements are 2 and 1. The outcome of the campaign is in turn affected by the conduct of the campaign, how the campaign was run, the information that the public is receiving, the conduct, every step that the campaign takes along the way, it will affect the outcome of the campaign. And for these reasons, we request that this court affirm the ruling of the previous court. Thank you.
Thank you, counsel. You have 4 minutes of rebuttal time when you're ready.
So opposing counsel made some points that I'd like to address. First, they said that this statute deals with fraud, and for that reason, it's not subject to the First Amendment. If this statute's intended to deal with fraud, it's doing a pretty terrible job of it. First of all, fraud requires actual harm to come about, and this statute says nothing about actual harm. It requires an intent to want to impede the conduct or affect to the outcome, but it doesn't necessarily require those things to be achieved. It's very much possible that someone could violate this statute without trying to defraud the campaign. Similarly, it's very much possible that someone...
This is an as-applied challenge here, right? So what could violate in some other case doesn't really matter, right? So maybe you could address, explain why there's not fraud here.
Certainly, Your Honor. There is no evidence on the record that Jenkins's actions actually caused harm to anyone. So therefore, it's not fraud. We can also, does that answer your question?
Well, I guess it's an intent to do so. I think like the questioning, I think the first time you were up discussed, there can be, there is an attempt to commit crimes. There's an attempt to commit fraud in many circumstances. And it seems to cover that, right? So does the First Amendment differentiate between attempts? It seems like you're suggesting And if you could point me to the authority for this, that when we're looking at the First Amendment, it has to be a completed fraud.
You're saying that the statute does not cover, or you're saying that the First Amendment does not cover attempted frauds?
I'm not saying anything, I'm just asking. So my question is, certainly in some circumstances, there are attempts. There's a whole
Yes.
slew of attempt crimes. I'm wondering whether what you're saying is, when it comes to the First Amendment, it has to be a completed, just use fraud, because that's what you said. There's got to be a completed fraud for there to be a problem.
So you're asking if attempted fraud is covered by the First Amendment. I would say, since this is an as-applied challenge, that question, I don't know that it's particularly relevant. There is no...
It is to me.
Okay.
Just playing with you. Go ahead.
I would say yes. If Julie Jenkins was attempting fraud, then her conduct would not be protected under the First Amendment. But in this case, it is the position of the petitioner that she was not attempting to defraud the campaign. She was, even if you assume that she is not doing this just for the truth, and she is trying to bash the campaign, she doesn't necessarily gain any benefit from that herself. Now, counsel had also mentioned that U.S. v. Alvarez basically says the government can restrict false statements. That is not correct. What U.S. v. Alvarez says, and in fact, in the case overturned a conviction saying that false statements are protected. U.S. v. Alvarez said that if the government is going to restrict false statements, it has to have a very much compelling interest. An opposing counsel brought up that there is perhaps some hypothetical compelling interest in this case, that the government might see some benefit in preventing journalists from destabilizing campaigns by reporting information. But if we go and look at Animal Legal Defense Fund v. Reynolds, that specifically says when we're analyzing these things and the government's justification, there has to be a direct link. That is, there has to be actual evidence that this statute is preventing harm. And there simply is no evidence on the record to suggest that Julie Jenkins' conduct harmed someone, or that if she did not conduct her conduct, it would have been better for anyone. So while the
Does
government...
Reynolds say that question is an evidentiary matter in the case, or an evidentiary matter at the level of sort of constitutional evidence for the state's justification for the statute?
Your time has expired, but you may answer the question and briefly conclude, counsel.
I apologize. What were you asking?
Oh, and you're saying the evidence supporting that state interest, is that evidence in the case, so the evidence of what Jenkins did, or is that evidence in terms of what the people who passed the law were thinking about?
Evidence in the case, there simply has been no evidence, or I suppose I should say the lack thereof. There has been no evidence in this case to suggest that Jenkins' actions have actually brought about harm. Your Honors, it seems I am out of time, so thank you. The petitioners today, we are asking you to vacate Jenkins' convictions and enjoin the state of Buckeye in part or in whole from enforcing 3517.21A1. Thank you.
Thank you, counsel. Judges, please complete your score sheets. We will then pass them to my right, where they will be collected, and then we will have some feedback for our competitors.
Don't judge us as we get out our calculators.
For the record, we've been judging you. I think it's fair for you to judge. Yes, some very intense questioning, and I think an extremely hard problem. The First Amendment is a difficult area of law. I don't mind sharing with you that it was one of my lowest grades in law school, my First Amendment class.
A minus.
Yeah, right. I want to commend you all for spending time out of your lives to be here with us today and to participate in this program. It's just incredibly important that citizens of a democracy care about its government, care about its laws, care about its constitution. It is indeed how we keep the republic healthy. So I'm delighted and proud of all of you and everyone here for being here. I just think it's wonderful. You all did a good job. It might not feel that way at times when you're being subjected to the kind of questioning that we had today, but standing there, not losing your cool, and particularly one thing I loved, even when things were not going well, is when you collected your thoughts, you didn't or you didn't like or stammer, you just sat there and thought about it. And that is what you do. Because however long it feels to you, and I'm sure some of those pauses felt really long, it doesn't feel that long to us. Things always feel longer on the inside. But you all did a great job, and you have everything to be proud of. Thank you for being here today. I'll turn it over to Mr. Hendershot.
Oh, sure. I echo all those things. As this program, I think, was something that arose from a conversation I had with somebody probably when you were all in elementary school or even younger. I hesitate to think about how young you were when I had that conversation. You all did a great job. I really enjoyed, to echo Ben's comments, some of the moments where I think you probably didn't know the answer when I was first asking the question, or someone else was asking the question, and later something came to you that really did offer some kind of pushback to where the question was going, and that skill is really important. I really praise you all for taking the time out of all the other things you have going in your life. In my job, I do what you're doing, 50 hours a week. I get a lot of time to think about doing it. You don't have that. You're volunteering your time to do it. So it means a lot to me to see you doing those things at this age. I'm not going to go through specific things. I have some stuff written down here. I'll stick around if you want to talk to me, if you want to subject yourself to that. I'd be happy to. But that's where I'm going to leave it for now.
Hello again, Attorney Hannah Botkin-Doty. I am incredibly thrilled and impressed not only with the evident amount of time and effort that each one of you has given to studying the text, to studying the facts, but also your resilience. We gave you some 8-layered questions, and I respect not only your intent ability to interpret, understand, prepare a response, and then respond in the span of 4.5 seconds, but also giving yourself a break to go, can you repeat the question? Implicit in that, which was, what on earth was that question? So yeah, good job. Way to maintain your sort of sense of realness. And it is evident that you all are incredibly intelligent, incredibly charismatic, and on your way to an incredibly bright future. So thank you very much for giving us a time to witness your brilliance.
I'm going to say you all did a very great job. When I was your age, I was nowhere near the level that you all and all the competitors are. So I really want to commend everybody for the great job that you've all done. Again, I think it was a tough thing. And this one, too, I think that I kind of felt like the people arguing the statute issue, that was a little tougher. I think there's more meat to the First Amendment. So I think you had a harder hill to climb. So, good for you for taking that one on. I just thought you all did a great job. Especially under intense questioning. I kind of ended up being the Clarence Thomas of this bench because they're all asking all these intelligent questions, rapid fire, and I just can't get in. So for you having to answer, you did a great job. So good job.
I would echo the good job. I know this is a difficult fact pattern. It's actually based on a case that I had where Ohio has this statute, and I was defending it. So it's a real statute, it's a real First Amendment issue, and you guys did a great job for having it for a couple of months, for being high school students, not having gone to college or law school. You should be very proud of yourselves. Everyone in the audience that's here to support you should be very proud of yourselves. So good job. And I would, if I were you, take Mr. Hindershot's offer up. He is incredibly knowledgeable on everything appellate work. So if you have that opportunity, I would do that. But good job. Congratulations.
I believe that concludes our program, but I'll check with Mr. Susky.
All right. Congratulations. Am I getting picked up? Congratulations to both teams on a hard-fought round. At this time, we'll go ahead and excuse our judges as we go into our award ceremony. So we'll do an all rise. And our judges may process out. All right, you may be seated. Actually, I'm going to step up to the podium to do this. All right, so congratulations again to everyone who competed today in the 2024 Moot Court competition. Moot Court is a very rigorous program. As many of you may know, a lot of hours go into learning the case law and the facts for this pattern, so we are immensely proud of all of you and congratulate you on the efforts that you put in today. We want to make sure that we thank several people who make this competition possible. First and foremost, a thank you to all of the teachers and advisors. Your guidance and support are invaluable tools that help these students to accomplish what they put forward today. A big thank you to all of our volunteers who served in judging our rounds today and to those who evaluated the briefs electronically. We could not do this without you. A big thanks as well to the Ohio channel, who has filmed today's final round and is live streaming this on their channel. And of course, another thank you to the auxiliary sponsors who make all of these programs possible. The Supreme Court of Ohio, who is hosting us in their building today, the Office of the Ohio Attorney General, the Ohio State Bar Association, the ACLU of Ohio Foundation, and the significant grant support we receive from the Ohio State Bar Foundation. With that, we have several individuals to recognize for their accomplishments today. First, I want to acknowledge our semifinalist teams. When I call your team's name, please come up to the awards table to receive your semifinalist plaque. A congratulations to Upper Arlington High School as one of our semifinalist teams today. We would also like to recognize our other semifinalist who was not able to stay for the final award ceremony, but a congratulations to Mason High School, who was one of our other semifinalist teams today. All right. In addition to competing for the team award and becoming the state champion, the students today also competed on individual awards to become our best advocates. At this time, we're going to go ahead and recognize the individual achievements for best advocates. When your name is called, please head up to the awards table to receive your medal as well as your certificate of merit. We're going to begin with the third place best advocate for the petitioner. Congratulations to Ezra Liu from Upper Arlington High School. And a congratulations to the third place best advocate for the respondent, Narissa Holbrook from Danville High School. Our second place best advocate for the petitioner, Alexander Ament from St. Ignatius High School. Our second place best advocate for the respondent side, Muhammad Khan of Talawanda High School. Our first place Best Advocate arguing for the petitioner is Thomas Liu of Kings High School. And our first place Best Advocate for the Respondent, Aaron Sharma from Mason High School. All right. At this time, I had the distinct pleasure of recognizing the 2024 Moot Court State Champion. We're going to recognize the champion first. We're going to ask that you go up to the awards table to receive your medals and your trophy. We would ask the advisor to please step up at that time to list off the students' names for the winning team and make sure they each receive their medal. Our 2024 Moot Court State Champion is St. Ignatius High School. I should go with Daniel right there.
All right, so we'll start with our timekeeper. This is Griffin Fitzsimmons. And Patrick Heimloff, our other timekeeper. For our attorneys, we had Ethan. Adornetto. Maxim Napora. And then our lead counsel, Alex Namath.
All right, congratulations to St. Ignatius High School. We'd also like to recognize the tremendous efforts of our Moot Court State runner-up, Kings High School.
Our timekeeper is Lily Mueller. Our petitioner, statutory, would be Christian Cora Zambrano. Our Thomas Liu is also the petitioner, constitutional issue lawyer. Who is our respondent. Statutory.
A sincere congratulations again to all the student competitors today. Truly, very nicely fought. Lots of hard work went into today, and you should all be proud of your accomplishments. With that, safe travels to you all. Have a great evening and weekend, and we hope to see you all back in 2025. Thank you.